Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican or in service Latino.
Is that correct?
I didn't ask you to interrupt me. Oh, for Trump's sake.
Good morning. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Good morning. Morning came early today. I don't know why, or maybe I slept late. A little of both. Yeah.
If they didn't, I would lose my mind.
We need our control station, battle station controls at the ready here. So we'll get that set. I'm sure we're going to need the replay sometime today. So, all right. Happy Thursday to you. Happy Podcast Thursday, I might add. Later tonight on this channel, the not relevant podcast will be happening. Saw chicken fighting. Oh my goodness. I ate waffles with syrup this morning, and I felt really good immediately after. But now I'm just like the sugar rush wasn't enough.
People do not get to have it their way.
Yeah, don't get to have it their way. Welcome, Kaylee. Kaylee, first in chat. Kaylee, congratulations, first of all. Glad you're back with us. A cruise over now, or your trip's over? I think it was a cruise. Did you go on a cruise, Kaylee? I'm thinking you went on a cruise. If not, a cruise is in your future. I'm just seeing it. Welcome, you're first in chat, and so we're going to punish you, Kaylee. I know that doesn't seem fair, but life's not fair, and I'm not here to make it fair. So, yes, cruise to Alaska, back in Florida now. Yes, good to hear. Get to work. We're sentencing you with internet ownership. You're responsible for maintaining everything IP-related worldwide. And so, yeah, there's that. Kaylee, congratulations. This goes on your permanent record. You can download a copy of this offense in certificate form from our shopping page on the YouTube channel for the low fine of just 50 cents. All right, no pressure on me, Kaylee. I mean, I feel much better having given that away to someone. You, on the other hand, might have a bit of a rough day. Jennifer Juniper is already doing the warm-ups, leading everyone in la 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 la's, which are great. Did anyone take junior high choir? And that was the warm-up you guys would do? My piano teacher, I still remember, I saw her the other day. She looks like identical. I think she's an android, a robot. She looks identical to how she did when I was in junior high, in 7th grade or whatever. It might have been 8th grade when I took choir. I took choir because my friend was taking choir. And anyway, Miss Baker, I'll out her name was Celia Baker. She was a charger. Yeah, that was our mascot was a charger, which I think is the horse that gets ridden by the knight. We were the chargers. Our mascot liked to look like the knight, but I think we were the horse. Anyway, go to choir, and she would always at the piano. She'd like warm up, and she'd sit at the piano. She'd be really energetic, trying to get us to sing. And a bunch of 8th graders, and half of them being boys, trying to sing on tune. It doesn't happen, right? And so she would play the piano really loud so that we could hear the notes, the la 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 la, and she would step up and down. And there were some people who were like la 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 la. That was all we'd get. And she was aware. She was aware that she wasn't dealing with a world-class choir. And she would try to help people a little bit, but without singling them out. She wouldn't be like, okay, wait, everyone quiet. You sing. She wouldn't do that. She's like, all right, this section. And she would always include like people that could sing and people that couldn't. And she's like, okay, try it again. Listen for the note. Yeah, it was so bad. I'm sure we did a couple choir performances, but the only people that showed up were like parents, and it was out of pity. I don't know why we're talking. Oh, we're talking about this because Jennifer started doing warm-ups. That's why. Anyway, I like that class. I liked that class. And she was a great choir teacher. I liked that class because my friend who's in the class introduced me to a really cool author for fantasy novels, which I liked, like knights and magic and fantasy when you talk about that. In that classroom, so I first learned about David Eddings, who was a great author when I was in that classroom. I read all his books, but good stuff. Anyway. That was a squirrel moment for sure. I think it's time to sing it to the birthday people. So I was in a school choir, no idea why. It must have been a required class or something, like it checked a box. I think it was either like you have to go to choir or you have to go to home ec, which is what they called the cooking class. And when I was in 8th grade, right now I'd be like, yeah, send me to the cooking class. That's the most useful thing I could go to because I need to survive and I need to eat good food. But in 8th grade, it's like, I'm not going to be caught dead in that room wearing an apron, right? I would sooner be caught by my friends in the library voluntarily checking out a book in junior high than I would be caught dead in an apron. That's just growing up. That's just we thought that wasn't cool. Now I think it's really cool. I'm like, yeah, I need a new apron for the kitchen. So anyway. It's going to be one of those days. I'm sorry. My mind is on a little bit of a scatter track. Let's see. Katia, hang on one second. I'm going to get to those messages. I will not miss yours. Here, let's see. Yours was first of the day right here. 7 months. Katia Pickles says, before my membership goes away, love being here. Glad to be back full time. Thank you all and RA for what you guys do. Thank you, Katia. I appreciate that. Love having you here. It would not be the same without you. Congratulations on 7 months. Also, Emily Arens says 6 months. Happy to be here. Look at that yellow courthouse. It's going to be orange before you know it, Emily. Thank you as well. Appreciate both of you for reaching those amazing milestones. I was in the choir, band, and flag corps. It says thrown his mind. In high school, I hung out on like band hall because my friends were in the band, but I had participated so poorly in some of my classes that even in high school, my electives became more like requireds, right? I was not a good student. Not that I'm not smart. I think my mom would tell you that I have the capacity to learn if I just put my mind to it, right? And I was not the one to put my mind to it. So I would hang out in the halls where I liked to hang out with, but I didn't have room in my schedule for band. I did take guitar in high school, which the guitar I own now, thanks to my wife, is the guitar I used when I learned to play the guitar. So we bought it from a sibling. Anyway, all right. Include Jenny in the birthdays. All right. We just got, Sharon, we just got one added like right as you were typing this. All right, let's do the birthday song now that we've all talked about singing in choir. You have no excuse. You're taken back mentally to when you were in choir originally, and you know how to sing in a group. So let's see. We're gonna add Jenny to this list. Jenny, Katie, and Yana celebrating their birthdays. So join with me as if we're in 7th grade choir. It doesn't matter if you can sing or not. You just have to belt it out. If you absolutely refuse to sing, you must dance. And I mean, literally, you stand up, dance, get those feet moving, get the blood pumping, wave those arms, jazz hands. We need the whole works today. So warm up with me, if you will. La 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 la. Excellent. Well, good enough, I should say. Good enough. You tried. All right, we're going to sing to Jenny, Katie, and Yana. Blend your voices with mine, project to the back of the room. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Katie, Yana, and Jenny. Happy birthday to you. Katie, Yana, and Jenny, happy birthday. Of all the days to celebrate, today is the one to celebrate you. I thank you very much for being here. There are a million places you could be, a million people you could be with. But here you are with us, celebrating. Privilege and pleasure is all ours. Hopefully we can make your day a little more specialer. And you can start it by making it specialer by going down to IHOP and Denny's or Village Inn. There we go. And getting your free pancakes. Katie, Yana, and Jenny, thank you very much. Have a wonderful, wonderful birthday. We'll let the music keep going as the dancers don't look like they're going to finish anytime soon. Great work. Happy day to all who this may apply to. We got the cha-cha-chas going. Jennifer, high kicks, were they a good job? Yeah, they looked great, ladies. I can tell you've been stretching. You're reaching new heights with those high kicks. Islands Princess says, hope you all have a fantastic day. I think that was our drum cue. You can't stop us, says Alicia. You can stop the music, but you can't stop the dancing. Dancers were spot on. I love the what's it called? When you're all in unison. The synchronization. That's it. Just curious how your idea to sing Happy Birthday came about. I cannot remember, Rick. It just happened and it was the right thing to do. Oh, there's our drums. Drum cue. Everyone go find your air drum sticks because we have a drum solo coming up at the end. It was absolutely beautiful. You guys were phenomenal. We'll do it again tomorrow. So keep practicing. Thank you, one and all. We have, where we are in court right now is we are about to start Sarah next week. I know it seems funny to say that because so long it's been like, oh, next year or, in 6 months or 8 months or something. And now we're finally to the point where we can say next week. Next week, Sarah starts. That's where we're at. So we're not starting any other big cases until Sarah because we don't want to get a third of the way through one and then bail. So Sarah is coming up next. We did watch the hearing yesterday. I appreciate those of you who joined us for that. It was a spicy one. If you missed it, I would say it's worth going back and watching because it gives you a big sort of window into what will happen when the trial starts, because we even got to hear from Sarah Boone. She took the stand, as she will in her trial as well. So that preliminary hearing was spicy. I'll tell you right now, I'm going to spoil it. Defense got shut down on some must-win arguments. They got shut down, and they're really up a creek now, is what I'll say. They have one last hope, and that is they're able to convince the jury that this was a battered spouse situation, which is going to be tough because one of the best witnesses against that is Sarah Boone and her testimony she gave to police officers. So there's Kadia says, I posted a video with my voice. That is awesome. We'll have to check that out. We had some fun with an old SovSit case, and it was old from like 9 days ago. Thank you, Josh, for queuing us in. Let's jump back to Judge Oakley's courtroom because he's handling some small cases right now, and he's a bit of a firecracker. We like him. We haven't seen him a ton, but let's jump back in and see what he's doing this morning, and then we'll go from there.
I can go to. And that's not the only option. We've actually set up a new program with the city of Romulus where you show up on a Monday or a Friday and you work what amounts to a 6-hour day, and we're paying you better than $20 an hour. I mean, we're not paying you, but we're knocking that much off your debt. You follow me? So on the way out, you want to talk about options, just talk to Mr. Taylor. But on this file today, I'm going to give you 1 day in jail, close it out.
Not sure what he did there, but he gets to work off his fines. The Honorable Brian A. Oakley, presiding judge.
Yeah, I've already go. Okay, you all set? Miss Hunter.
Good morning, Your Honor. This will be a quick one.
Yeah, well.
Attorney Josh Edward, on behalf of the defendant, Ms. Ayden.
Is it safe for me to assume that you don't object to a dismissal? Is it okay if I dismiss this case?
Yes, sir.
Okay. No,
I'm sure you got the motherly lecture from me about the friends we keep. I think you can guess what the charge is and why it was dismissed. And that's really what the case was.
Yep. All right. You all set? Have a good day.
He's like, get out of my courtroom. Dismissed. Go, go, go. I think that's it.
Can you talk real quick?
Sure.
Hold on. Do you want him to call you or talk on this phone? Hold on. Yeah.
Yeah. Yeah.
When I don't, strangers like friends.
Green-eyed cat, can you send me the case name, all the information you can?
Rear wheel. When she's turned, and it's, to me, it's the back, not the front. That's terrible. But you don't have to hold that. Don't do it. I know specifically the last 1,000, I noticed it when she was like making a left without stopping. But I think it was also when she stopped.
It's just a hot mic. I'm not sure what the traffic situation is. Green-eyed cat, send me everything you know about the case, the judge, the county, the date, the defendant, charges, things like that. We can try to get it on the calendar. That's the Nova case, Fairfax County. I think, correct me if I'm wrong, I think TYO Toys might be in attendance on that one. I think Phil is going there, and possibly we're looking at getting him some equipment for that. Just hold tight on that one. I'm not done lining that one up, if I remember correctly, because I think he's up in Virginia. So, but it sounds very interesting. I believe that's the case. Thank you very much. I think, Amber, if you're not busy, Amber's always busy. Rob's also there. Law and Lumber is close. I'm not sure if he's going to be there. Rob has a busy practice. I mean, he's a full-time lawyer, right? So he does that, and then he does YouTube when he's not busy, which is always. I'm not sure if he's going to have time to go to the trial, but he might. That would be great. I would love to get his take from the inside. When you're not busy, or Josh, if we can do a little research on the media access in that court, I just need to see the requirements and the forms and things like that, who I have to apply to, if you can help with that. But yes, that is the husband, the au pair. I think that one is going to be juicy. It's going to be spicy for sure. But it's one of those cases that I think we do want to follow. Virginia is a witch for court access. I think you spelled witch wrong. We'll keep an eye out on that one. We have ways. We're getting ways to get around some of the states that are just a pain in the backside. Green-eyed cat. If that's the right one, I think our mods can run with it and get me a little information that I need on my side to do the paperwork to gain access, or attempt to gain access. Creative language, family show. Appreciate that, Amber. Always mindful of the audience. Let's see who else. Simpson was supposed to be live. It looks like he just came live. Yes.
4 weeks is appropriate in this case.
I'm sorry.
For an adjournment of PCC to complete discovery review. Okay, thank you, Judge.
October 24, 2024, 9 a.m.
Bond will continue.
And, Your Honor, I'd also like to make an argument regarding bond. We understand why bond was set in this matter.
That bailiff is right.
And as recently as this morning, I've been notified of some additional information that would violate, if true, the conditional bond of Mr. Adamson. The primary basis for my request for a bond reduction is the youthfulness of Mr. Adamson and his fact that he's unfamiliar with this system.
He's young and dumb.
The priority of bonds and his ability to follow them, it has to be 100%. This is not, trying hard doesn't get it. I've just met with Mr. Adamson for the first time yesterday. His behavior moving forward is going to change. He has promised me that. So we would ask for Your Honor to reduce to a nominal bond because he does still have a bond out of 14B that's going to keep him until at least the 28th of this month. But because of his youth and inexperience, he has no prior record. He has no convictions on his record, I should say. We would ask for a bond reduction in this matter.
Respond.
He has no conviction.
There was a conditional bond order out of 14. He wasn't supposed to be contacting the victim when he did, when these incidents happened. He's been charged with patient first, assault GDH, DDAG, the MDOP. He said he was supposed to be over at her house because there was a conditional bond. Kicked open her door, strangled her, dragged her body, assaulted her. He has been contacting the victim. He's called her 15 times since he's been incarcerated this time around. So he's already violated the conditions of the bond. He was violating the conditions of the bond in 14B, and now in this case, as they've been said. So I ask you to keep on the same.
Anything else?
Your Honor, he's been instructed properly, I know, at least yesterday. I anticipate, and I believe he's going to promise.
But he was instructed on the 14B matter and didn't seem to care.
And Your Honor,
he was instructed at arraignment not to make phone calls and contact with them, and then he did it. While I'm certain your efforts would be admirable in terms of getting it through to him. I don't think he gets it.
He's going to have to prove it with his behavior, Judge, and I understand that, and I think he understands that.
Motion for bond reduction is denied. Defendant's phone privileges are hereby ordered revoked.
Ooh, no phone. Bond is probably still at like 50 grand or something.
Court does call the case. People versus Maurice Anthony.
Anthony, for the people.
Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Anthony. He was in the courtroom. I think he may have gone to the restroom, but if we could just he was here.
That's it. Court calls the case. People versus Javari Holmes. Tuesday.
A lot of people left after that last
on behalf
case.
of Mr. Holmes on one of the two matters. Ms. Costantino represents him. The other one,
Ricky,
just like she stepped out of the room. I did have
what?
Sorry.
No, we'll wait.
If it helps, I found my other client.
Oh, joy.
Christina Costantino appearing on behalf of Mr. Holmes.
He scared me there. Thought he was going to come down on somebody.
And both of you are your name, sir? Javari Holmes. Thank you. And you guys are requesting an adjournment?
Yes, Judge, that's correct. Additional time is needed for both discovery, investigation, and negotiations.
How much time are you looking for?
Judge, I'd ask for 2 weeks.
Will that work for you, Mr. Overwater?
It wouldn't.
Probable cause conference, October 17th, 2024, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. You're damn busy. Court calls the case, People versus Alexis Archer.
That's one of the people.
Good morning, Your Honor. Alexis Erb, student attorney seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Natalie Pate.
Who?
Assistant Public Defender Natalie Pate.
Oh, there she is. Okay.
Who?
Permission to practice experiment.
Alexis Erb with and on behalf Ms. Archer.
Did she already say that? Okay, go ahead.
Please state your name for the record, ma'am.
Alexis Archer.
All right.
Your Honor, we're requesting an adjournment so that Ms. Archer can continue seeking to hire private counsel.
Did she get an adjournment before for that purpose?
I don't believe so.
How much time are you going to need to get private counsel, ma'am?
I know there's already been talks, so just a brief adjournment, I would think. 2 to 3 weeks, maybe, Your Honor.
This is the only adjournment you'll get for this purpose. October 17th, 2024, 9 a.m. Bond continues.
Thank you, Your Honor. Thank you, Your Honor.
Court does call the case People versus Kyle Lowe.
Pretty much all our courts in this nation are just slammed. Crime apparently is happening everywhere.
Good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Lowe, who's approaching to my right.
Mr. Lowe in white, that signifies he may have some mental...
Your name, sir? Kyle Anthony Lowe. Thank you. All right. You're requesting an adjournment in this case?
Yes, Your Honor. The mental health court at 15th District Court, I talked with them yesterday. They're going to be able to come to the Washington County Jail and interview Mr. Lowe to screen him for admittance. They will either be doing that today or tomorrow. So they just need 2 weeks to do that and get the report.
Okay, so it's not 2 weeks to get the screening. It's just that they need 2 weeks to
put all the puzzle pieces together. Yes, Judge. So they asked for the adjournment, and Judge, I need you to be like Under Armour and say, I will. Yeah. I heard you're not a big Nike fan.
I didn't say that.
Yes,
I know, I did not say that. It's all Bellinger's fault. I just said I prefer Under Armour because it was
Under Armour
by a University of Maryland grad.
And Under Armour's slogan is I will. So Judge, I just need you to be like them today.
I'm aware. Why is she talking?
Why is she talking?
October 17th, 2024, 9 a.m. Bond continued.
Thank you, Judge. I'll see you on the 17th.
Oh, joy.
Oh, joy, says the judge. Oh, joy.
This is good. Court does call the cases of the People versus Mark Austin. All three cases.
He's down at the bottom on Zoom.
We're ready in this matter. I'm Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Austin. Mr. Austin appears from the Forensic Center by Zoom.
In the conference room, apparently.
Yes, ma'am.
Number 534 on the bottom is an arraignment.
Oh, yes.
Not sure why they went off the record for this one. The Forensic Center. That's for mental health evaluation? Forensic Center? I don't know.
Y'all know why we came? No.
So this case is being handled off the record, probably for its sensitivity. The judge has muted his side of the mic, but we're still hearing the Forensic Center side, which is interesting. I don't think it's pink. I think the camera is, the white balance is off. The walls look mauve. I think the walls are white. Once you correct for that, take the pink out of the walls. It would also take the pink out of the woodwork, and it would go to a light tan, probably a little bit lighter than what's behind the judge, just behind his head. It's just a color balance issue. Fun fact, says Red Pen, our visitor's locker room, Loa has painted that color to psych out the opponents. The away team is pink. Bite Me says, did you check your burner? I will check my burner right now. Got a lot of messages. Hang on a second.
In this case, based upon the reports that the court has, that the court will sign an order, the defendant is incompetent to stand trial and is at this time not restorable. People will make their decision as to whether or not to petition the defendant. That is applicable to cases ending in 0442 and 0767. In the other matter that is set for an arraignment on some new charges, what I will do to allow people to make decisions about this case is I will adjourn the arraignment to November 14th, 2024, 9 a.m.
Require a green sheet for these two things.
I can't read your writing anyway. Court calls the case People versus Lauren Somerville.
Morning, Your Honor. Edward Drukas on behalf of Lauren Somerville.
Good morning. Your name?
Lauren Somerville.
Welcome back. All right.
Your Honor, we're asking for a 2-week adjournment. There's some outstanding video that we're going to be looking for. I've spoken with the prosecutor and also sort of following up what's going on in circuit court. So,
pardon?
He also has a violation of probation hearing set for early November in front of Judge Conlon. So,
early what date? November.
November 13th.
Yep, the 13th.
You want this before that?
Yes, Your Honor.
All right. Probable cause conference, October 17th, 2024, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you so much.
Oh, Your Honor,
yeah.
It was, I believe there might be a PR bond in this case. I'm asking for a nominal bond. Or there might have been a bond that was posted. There was confusion with that.
What do you have? Actually, I have it from arraignment and a PR setup. Yeah. Well, this is your first hearing, right, on this? Yes. So it's got to be a PR, huh? Yeah. PR. Okay. I'll change it. Set his bond at a $1,000. 10% bond.
Thank you, Your Honor. That's all. Thank you.
Trying to read and respond to all the messages from this morning. Give me just a minute.
That was called the case People versus Noah Hartzman.
Assistant Public Defender Natalie Pate on behalf of Mr. Bartman. Your Honor, may counsel and I approach?
Seriously, that's just like my third one this morning. Yes. Where's Mr. Bartman?
Bite Me Rebecca got her Sarah Boone shirt that Greener's designed. Send me a text. That is awesome. Rebecca, that is really cool. She's super happy about it. You wear it better than I do. Let's see. Sorry, I'm trying to get caught up. Oh my goodness. Cheerios, dill pickles. That's funny. Okay, we're getting slowly there. We've got court case notices. Whoa. I can't read the one I'm reading right now. But
all right, record reflects we've had a bench conference in this case. I will grant the adjournment in this matter. I'll adjourn the probable cause conference to October 31st, 2024 at 9 a.m. I'm going to also, because of circumstances, cancel the community corrections bench warrant and reinstate his previous bond.
Thank you, Your Honor.
Thank you.
I don't think Melissa would mind, but
court calls case People versus Sheena Stout.
Ask that you keep Matthew and Melissa in your prayers, as things are still going on there. Health-wise, they could use all the support.
Assistant Public Defender Jay Bellinger on behalf of Sheena Stout, who appears to my right on case ending in 5225, Your Honor. And I believe Ms. Frazier is on the other two cases, Your Honor.
Where is she?
I have community. There she is.
I apologize, Your Honor. Marcia Kutcher on behalf of Ms. Stout in the cases now 5224 and 5231.
Hey, what are we doing?
Your Honor, I was just appointed on 5224 because the PD withdrew, therefore discovery is not complete. I'd be asking for a 2-week adjournment.
And we would asking to follow suit, Your Honor, so that Ms. Frazier can catch up.
October 17, 2024, 9 a.m. bond
continues.
And Your Honor, if we may address bond. Not to, we were just requesting that she might be able to go inpatient. She did just start, she actually is starting Don Farm's in-jail program 2 times weekly.
How close is she to finishing that?
She's just starting those today, Your Honor. She was just able to enroll.
She won't be released to inpatient until she's completed in any of her.
Okay.
So I'm not going to do it.
Okay. All right.
This time.
All right.
Thank you for your consideration, Your Honor. Appreciate it.
Okay. Okay. All right. Thank you, Your Honor.
Thank you.
They had 2 lawyers for her, both arguing.
Let's call the case People versus Emily Bates.
Honor Alexis Pluma appearing on behalf of Emily Bates. Any chance Miss Bates is present over Zoom?
Emily Bates? Nope.
Honor, I have not been able to reach Miss Bates. She typically does appear over Zoom. I don't think she has failed to appear since she's been having probable cause conferences, and this is the first time that I or anyone else from my office has been unable to reach her, so I'm not sure what's going on. She's usually very responsive. I would request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond set at 10,000 cash surety.
So you knew the bench warrant was
will
coming.
issue immediately.
Thank you, Your Honor.
Thank you.
There were 2 case numbers. I wasn't paying
Court calls
close
case
attention.
People versus David Stevenson White.
That's a lot of the people.
Good morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Assistant Public Defender Jay Bellinger.
Really?
I know.
Bellinger?
I don't have any t-shirts today for you.
It's okay. All right. Permission to practice is granted.
Thank you, Your Honor. Your name for the record.
David Stevenson White. Oh, you didn't get her name. What's your name again? David Stevenson White. No, not you. Oh, I know what your name is. I got your file. You're in green. I got you. All right. Your name.
Hannah Mackey.
Got it? Hello.
Makki.
Have you appeared before me before?
Not before you.
I didn't think so. That's why we don't have any. Where are you from?
Where?
Where? That's a question. Yes.
Like Michigan.
Okay, that's a good start. What part of Michigan?
Ann Arbor.
You're from Ann Arbor?
Yes.
Where'd you go to high school?
Divine Child in Dearborn.
Oh.
She's one of those.
Couldn't stay here.
Oh, that's a good school.
Where'd you go to undergrad?
Michigan.
Where are you in law school now?
It's just going to get worse every time you ask. Michigan State.
The whole courtroom goes.
Can't. Probably should have just not told me the truth. Okay. It's okay. We got you. We'll talk slow. All right.
That was a zing.
Had to take the shot. What are we doing in this case?
Your Honor, Mr. Stevenson is prepared to waive his right to a preliminary examination.
Sir, is that correct? After all that? Yes. Okay. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. Sorry. And you understand that you'll not have that hearing and you'll proceed to circuit court for further resolution. Sir. All right.
Your Honor, we waive formal reading of the complaint.
Whoa.
Acknowledge receipt and my client.
Whoa. How'd she just do that? Bellinger.
Yes, Your Honor.
How'd she just started jumping in?
Well, Your Honor.
Okay, all right.
I was told when you look up at me to say it, so.
Is that what Bellinger said? Is that what he said? Oh, don't listen to what he says. When he looks at you, do something. Listen, okay, just slow down.
Okay.
Okay? People also waive their right? Yeah, you forgot that part. Who's?
He's looking at me.
I'm like,
do something.
am I in the middle of this? No, you're good. You're good.
Am I the bad guy?
The attorneys, they're out of control.
It's not my fault.
No, this is not your fault. The other part was.
Yes, Your Honor.
Do the people waive their right?
To a preliminary exam? Absolutely.
Okay. Preliminary examination having been waived, defendant is bound over to circuit court on the single charge. Now I'll look at you. Go.
Your Honor, we waive formal reading of the complaint, acknowledge receipt, and my client will stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
October 22nd, 1:30 before this complete.
October 22nd, 2024, 1:30.
So this is all fun for all the lawyers and the judge.
Will continue.
The defendant.
What?
I've seen Ms. Conti today too, I think.
You do?
I believe. If I'm not mistaken.
Okay, well, good luck. All right. Thank you. Take care.
The defendant has no clue what's going on, and why people are laughing and what's funny.
Oh, is she? Don't be embarrassed. You're good. You're not? I would be. All right. So, court does call the case. People versus Teresa Johnson. She's in Zoom.
Yes, sir.
Oh, and you're back.
Hannah Mackey, on behalf of Miss Teresa.
Teresa Johnson?
Yes.
Miss Teresa.
She's in Zoom.
Oh, she's on.
Is she in Zoom?
Okay.
Okay.
What? Did they just give you the hard cases or what?
It's getting worse when I ask what I'm gonna say next.
Thanks for the warning. All right.
Your Honor, we asked
Go ahead.
to adjourn this matter to 3 weeks, and we'll seek to move it up on the docket if and when appropriate.
Pardon? You want to do what?
Adjourn to 3 weeks?
Any objection from the people?
No, Your Honor.
October 24th, 2024, 9 a.m. And what else did you want to do?
That was all.
Okay, good. Fine, we'll continue.
Thank you.
Don't say you want to put it out and then you're going back up later.
Because I don't know what she just did. Oh, I don't need these out unless I'm waving. Did I wave these? I don't need this out. So.
Oh, gotcha.
Just call the case. People versus Dolores Strickland. Yeah, relax. Go ahead, have a seat.
Ready, Judge. Torshell Feaster, Assistant Public Defender, appearing on behalf of Ms. Dolores Strickland. Ms. Strickland, please state your name for the record.
230 times Dolores Strickland.
Thank you, Judge. I have had many conversations with Ms. Strickland, and we were working with the people, with Ms. Tanner, to try to resolve this matter. Ms. Strickland had a particular offer she wanted requested. I asked Ms. Tanner for that.
You asked?
Ms. Tanner.
How'd that go?
She was not willing to give Ms. Strickland the offer that she wanted. Then I sent Ms. Tanner the mitigation letter just to make sure she had it, because Ms. Strickland wanted you to have it and Ms. Tanner to have it. I told her this was not the point for Your Honor to have a mitigation letter, but I did make sure Ms. Tanner had it. And you're asking for another adjournment so Ms. Tanner can consider the offer in light of the mitigation letter that I have made sure she had per Ms. Strickland's request.
So, do we have the...
Where are you going?
And also, can we do that as soon as possible? Because I've been in here, Your Honor, 230 days today, and I've got absolutely nowhere. And I also sent you the mitigation letter and a letter in the mail just recently. You'll probably get that too.
Okay. I know you've been in a while, but I also have 3 cases. So that may be part of the problem.
Altogether, from what I understand,
If I might, Judge, Ms. Strickland is hoping for a resolution that will not include any type of probation.
Oh.
And that is not what is being offered at this time. And that is going to possibly be a hang-up to resolve this matter.
And Your Honor, I told him that I would maybe consider it. It depends on how long it would be. But however, I do have family in Florida, that Tallahassee, the hurricane, things like that I really need to get out to see if they're even alive or what happened to them, because I can't find nothing out in here. And I talked to them through Messenger. That's the way I stay in touch with my family. And I know they got hit. I just don't know how hard. And I can't get no information because the only person that I have here is my ex of 15 years and my other kids that, I don't have their number right now either, because I cannot get to their number, and I do not have phone, which I need to ask Your Honor, can I get my phone privileges back on, please?
I believe they were restricted because she had contacted
violated a condition of bond, so I revoked them.
Correct.
I was already punished for that, Your Honor, because he had them block his number. So that should have no problem of me calling my brother and trying to get help from him or, contact him, because that's who I was contacting. I wasn't contacting my ex.
Okay, Ms. Strickland. Now, a lot of these requests that you're making.
It's because I got nowhere.
Okay, listen. You need to talk with your attorney about them.
Your Honor, I have.
Do you listen to your attorney as well as you're listening to me? That means not at all.
I got mental issues that just like I'm overwhelmed, very much so, Your Honor, but go ahead.
Thank you. Talk to your attorney about these issues. He'll talk to the prosecutor. They'll see what can possibly be worked out, if anything can be worked out. I'm not reinstating your phone privileges. You violated that condition of bond. That will continue revoked.
Then I'll just continue.
Okay.
Sorry, Judge. If we could have an adjournment so that Ms. Tana and I'm bad with names.
Ms. Rizmersky.
Ms. Rizmersky. I knew the first name. Ms. Rizmersky could consider Ms. Strickland's.
How much time will it take for them?
We only need a week or two, Judge.
A week, please, Your Honor. A week. Let's speed this up, Your Honor. I'm trying to. If you just read my mitigation letter, Your Honor, you can find out why.
Ma'am, that's the problem. You keep doing things that your attorney says it's not the appropriate time. When I get that letter comes into my office, I'm going to tell you I am not going to review it because it's not appropriate for me to see that. If you listen to your attorney, maybe this would go a little bit smoother.
Your Honor, my attorney's not telling me what I need to know. I'm lost.
No, your attorney's not telling you what you want to hear. He's telling you what you need to know. You're just not listening, like you're not listening to me. These matters are adjourned to the 17th, 9 a.m. On continue. Thank you.
Thank you, Judge.
Here, you can do this. I didn't do any.
A little sad and a little misguided. She's not in a position to bargain.
I'd like to say the same to you. Court does call the case, People versus Ronald Blackman.
Absolutely for the people.
Good morning, Your Honor. Student Attorney Alexis Zerbst appearing on behalf of Mr. Blackman, who is approaching.
Your name?
Blackman.
Oh, Ronald Blackman. Okay, you're good.
What's he wearing?
Thank you, Your Honor. We're just asking for a 2 to 3 week adjournment to
need to keep your hands out, sir.
To engage in further plea negotiations.
How much?
2 to 3 weeks, please, Your Honor.
Does it say North Face?
Probable cause conference will do the 24th, October 24th, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
October 24th.
It looks like he's wearing a sign, but I think it says hoodie. That was a weird getup.
You can let your client know. Apparently, we've inconvenienced him.
Oh, the way he walked out of court was a little bit
case,
of sass.
People versus Trenton Johnson, the second.
Good morning again, Your Honor. Christina Costantino appearing with and on behalf of Mr. Johnson. Mr. Johnson, can you state your name for the record?
Trenton Johnson. Thank you, sir.
Your Honor, at this time, we're asking to have this matter set for a preliminary examination.
All right. All discovery is complete.
To my knowledge, yes, Judge.
People have their witnesses available the 15th. Preliminary examination in person, October 15th, 2024, 9 a.m. before Judge. Keep covering.
Oh, I'm sorry.
Thank you. Before Judge Barr.
All right, Judge. Thanks.
Continue.
All right. Thank you. Have a good rest of your day.
Yes. Emily? No, this place is falling apart. I can't have you pay attention. Otherwise, I have to bring in a reliever. Court calls the case, People versus Cody Jolly.
No fault use on behalf of the people.
Mr. Jolly?
Your Honor, Mr. Jolly's here. However, he's refusing to get dressed and participate in court.
He's refusing participation. Okay, thank you. What I will do is I'll adjourn his probable cause October 31st, 2024, 9 a.m.
That might be fun to watch.
Thank you.
Thank you. And we'll continue. Court calls case People versus Darnett Blackwell.
Ready, Judge. Portia, the Assistant Public Defender, appearing on behalf of Mr. Blackwell. Mr. Blackwell, please state your name for the record.
Darnett Blackwell.
Thank you.
Thank you, Judge. I spoke to Mr. Blackwell in custody, and since that time, I have spoken to Ms. Blanche again. My understanding, she's going to be having a request regarding Mr. Blackwell phone privileges. But Mr. Blackwell is asking for this matter to be set for preliminary examination.
Discovery is complete.
As far as I know, Your Honor, yes.
People would have their witnesses available the 15th. Preliminary examination in person, October 15th, 2024, 9 a.m. That is before Judge. Sure. I mean, yes, Valvo. Esteban.
Judge, he has been contacting the victim from jail. I did send over some of the calls to Mr. Feaster. So I asked you to revoke his jail phone call privileges.
I need an order.
Your Honor, I did receive the email from Ms. Blanche this morning. I have not had a chance to listen to those, but obviously I understand her request. If the court grants her request, I will go and review it. And if I have a motion to file, I'll file something at that time, Your Honor.
All right, very good. Based upon those representations, the motion for modification of bond is granted. Defendant's phone privileges are hereby revoked pending here. Thank you.
Thank you very much, Judge.
Okay. Where do we have it? Okay. Court calls case People versus Dana Bosley.
Assistant Public Defender J. Bellinger on behalf of Dana Bosley, who approaches. And state your name for the record.
Dana George Bosley.
Thank you. What are we doing?
That is our understanding, Your Honor.
Pleading guilty to the charge?
Yes, Your Honor.
May I have him sworn?
Raise your right hand. Yes, sir. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. State your name. Dana Bosley.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs.
Yes, sir.
Is that true? Okay. I do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 district. You understand that?
Yes, sir.
All right. Understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form?
That's what you signed.
Yes, sir.
All right. Any questions regarding those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
Probation, sir.
Okay, out of where? What court?
Washington.
Washington. Okay. And were you on probation at the time of this offense?
Yes, sir.
All right. I do have to advise you that your entry of a plea in this case could be considered a violation of your probation. You understand that?
Yes, sir.
And you understand that as such, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, sir.
All right. And understanding that, you still wish to plead guilty to this one?
Yes, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, sir.
Anybody threaten you or coerce?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you're guilty of this offense?
Yes, sir.
On July 21st, 2024, at the location of 129 College Place, Ypsilanti, Michigan. What did you do involving an Amara Thompson that makes you think that you're guilty? You need to, buddy. Put your hands out of your pocket. Okay, go ahead.
There was an altercation at 129 College Place.
Okay, what did you do on that date? I understand there may have been an altercation.
Did you put your hands on her?
Yeah, I put my hands on her.
And who was that person?
Maria Thompson.
Okay. And did she want you to?
No, sir.
Okay. So it was not a consensual touching? Meaning that she did not want you to do it?
Yeah, we were fighting.
You were fighting?
Yeah.
And what did you actually do, young man?
I put my hands on her.
Did you shove her?
Yeah, I pushed her.
You pushed her?
Yes, sir.
All right. And you did that intentionally?
Yes, sir.
All right. And what is your relationship to her?
That's my child's mother.
Okay, so you have a child in common?
Yes, sir.
All right. Counsel, have I complied with the court rule, or would it be proper to accept this defendant's plea?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be November 7, 2024. What time? 10 a.m. before Judge Barr. Bond will continue. Thank you.
Okay. Contact 14A2, okay? All right. Thank you. Thank you, Your Honor.
Court calls the case, People versus Clinton Donald.
Ashalani for Pickles.
Good morning to this honorable court. Marigold, P number 62755 on behalf of Mr. Johnson.
Your name?
Clinton Donald.
All right. All right. What are we doing?
Your Honor, in this particular case, we have a resolution. My client is waiting to be accepted into 14B Recovery Court.
Has all of the paperwork been sent?
All of the paperwork has been sent to the court.
Okay. Did they give you, so I need to adjourn this out. So did they give you a time when they might be making a decision?
Okay, so this is the second time that we were in court with this. 2 weeks ago, we were in court and all the paperwork was in. I did follow up with the person that is over recovery court. She said that he would be evaluated. I was waiting for an email and I did email them Monday. I haven't got an email back. Mr. Donald, have someone from 14B came to see you?
No.
Nobody's seen you? Okay. Is this the only thing holding you?
Yes. And Your Honor, because he has been evaluated and the prior prosecutor believed, me and the prior prosecutor believe that he is eligible for that particular program. His mom is there. We're asking if maybe he can get on bond. It may be quicker for him to get into the program if he's out on bond.
That's not how it works here. But I don't.
But Your Honor, there's also other reasons why we with bond. His mom is there in the courtroom. They have had a death in the family, and she also is having some health issues. I don't want to put all her business on the street. So if we could get a bond for him to get out so that he can attend his health.
Counsel, I'm going to need a written motion on bond or a stipulation of the parties. I'm not going to try to address that now.
Okay, thank you.
I'm just trying to figure out a time frame. I don't see a referral in my file.
There was a referral
and I'm a little bit worried about that.
Your Honor, I can send this. You signed the referral form. I can send it to you.
Pardon?
You signed it over 3 weeks ago. I can send it back to the court.
It says on September 11th.
On September 11th, we have it in JIS,
Yeah.
but we don't have it in here. Okay. Oh, there it is. All right.
So just for the record, you do have the referral form, correct?
I've got it now. Yes, ma'am.
Okay.
All right. So what do you guys want me to do? Because if you haven't been interviewed, that part of the process can't move ahead. Is anybody over there told you when they will get over to see him?
So I have been emailing the program, the recovery court director, and he was supposed to be
It's not me.
interviewed last week. And I did do another email this week, and so I don't know why he wasn't interviewed.
Let me do this. I'm going to put this to October 17th. Put it out 2 weeks, 2024, 9 a.m. And I'll indicate his bond at this time will continue. And if the prosecutor could assist to try to see what might be the holdup.
Thank you, Your Honor. What I will do is later today or tomorrow, email Mr. Reyes, copy defense counsel, try to get an update.
All right, very good. All right, bond. Thank you.
Thank you. Bye-bye.
Court calls case, People versus Casey Boyd.
Morning, Your Honor. Brian Bowling, Assistant Public Defender on behalf of Mr. Boyd. Mr. Boyd, we have been unable to have any contact with him, Your Honor. I don't have any explanation for his whereabouts. Pardon? I don't have any explanation for his whereabouts.
Bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash. That warrant will issue immediately. Court calls case People versus Gartrell Effinger.
Brian Bowling on behalf of Mr. Effinger. State your name for the record.
Gartrell Effinger Jr.
Your Honor, at this time, we're requesting the scheduling of an exam. To my knowledge, all discovery is complete.
People have their witnesses available the 15th. Preliminary examination in person, October 15th, 2024, 9 a.m. That is before Judge Barr. Bond will continue. Thank you. Get more. Court does call the case of the People versus Jason Brooks.
Anna Mackey appearing on behalf of Mr. Brooks.
You're back.
I am.
Okay.
Please say your name.
Jason Brooks.
Your Honor, at this time, we are requesting a schedule of a preliminary examination.
All discovery is complete.
Yes, Your Honor.
She doesn't quite know what to do now. Would the people have their witnesses available October 15th?
Yeah, we'll do it.
Preliminary examination in person, October 15th, 2024, 9 a.m. That is before Judge Balvo.
Thank you.
Bond will continue. Thank you. Court calls the case People versus Donnell Fonville.
Assistant Public Defender Jay Bellinger on behalf of Donnell Fonville, who stands to my right. Mr. Fonville, can you please state your name for the record?
Donnell Ulysses Fonville Jr.
Thank you.
Your Honor, we are just asking to set for preliminary examination today, and we're also asking to address bond at the appropriate time.
All discovery is complete?
Yes, Your Honor, as far as we know.
People have their witnesses available the 15th. Preliminary examination in person, October 15th, 2024, 9 a.m. That's before Judge Barr.
Thank you. Your Honor,
as to bond.
As to bond, Your Honor, it's my understanding that there is no bond set at this time. I spoke with my client. I'm advised that part of his initial bond hearing at arraignment was Magistrate Fink advising all parties at the time that he had a conviction for an AWIM last year. I did not see that at all in his criminal history. I don't know what the court notes state. Obviously, I would just ask that the court take that into consideration and apply some sort of monetary bond for him, however high.
So she denied bond because of the previous conviction?
She denied bond. From my understanding, she denied bond for a previous conviction of an AWIM, but we did not even see that in his criminal history when we took a look. I'm not saying that it's not there. I just don't see it myself, so I don't know if that was an error. And I'm certainly not saying that Magistrate Fink is not capable of reading criminal histories, but I do want to make sure that the record is correct on that.
Did you ask him?
I did ask him, Your Honor, and he did state that that's what she stated. I asked him, and he said, I know.
Yeah.
He also stated
not what my question was, counsel.
He also stated that he did not have a conviction last year for an AWIM.
Response.
I have down the agreement that she denied it based on the fact that he had 2 prior assaulted felony convictions within the past about 15 years. Okay. There was a bullying assault, GBH strangulation that he was convicted of. So that's why she had denied him his bond at the time. I don't know about an AWIM. I wasn't there for.
Okay, and neither was I. And I don't know. My client's advising me right now that he says he's stating that he was never convicted of an assault GBH. Do you have the year or the? That's part of it. That's part of that title.
2015 assault GBH.
Okay. Your Honor, regardless, we would ask for some sort of monetary bond.
Regardless of the fact that
we would ask for some sort of monetary bond on this matter.
Are you saying that the magistrate didn't properly deny? Or are you saying that the magistrate doesn't have authority to deny bond?
I'm not, Your Honor.
Okay, you're just thinking that you want a bond.
At this point, yes, Your Honor.
I do not find an abuse of discretion on the magistrate's part. Bond will continue as denied. Thank you.
All right. Thank you. We'll work on it. All right.
Good try. Good effort. But yeah, if you've got a violent conviction passed, bond's probably going to not be low or set at all.
Bellinger, you should have sent Mackey. Court calls the case. People versus Tommy Butler.
Ready, Judge. Worship Feaster, Assistant Public Defender, appearing on behalf of Mr. Tommy Butler. Mr. Butler, please state your name for the record.
Tommy Butler.
Your Honor, please, this is the first.
He's angry about that.
Please, it's the first.
Big boy, it would have been a good fight. I'm betting on you. Go ahead. What? Sorry.
First PCC on this matter. The first PCC on this matter. I've spoken to my client and to the people. If we could have an adjournment so that we could sit down and discuss discovery a little further and see potential offers.
Okay, how much time do you need?
Just a couple weeks.
A couple weeks. Probable cause conference, October 17th, 2024, 9 a.m. Bond will continue. Thank you, sir.
Thank you, Judge.
Court calls the case, People versus Christopher Gruba.
This is Public Defender Natalie Pate with on behalf of Mr. Gruba. Stands to my right. Please state your name for the record, sir.
Christopher Gruba.
All right, what are we doing?
Thank you, Your Honor. As to both matters, Mr. Gruba wishes to set them for preliminary examination. Discovery is complete to our knowledge.
I like this public defender.
People would have their witnesses available the 15th. Preliminary examination in this matter will be set in person October 15th, 2024, 9 a.m. That is before Judge Spalvo. Bond will continue.
Thank you, Your Honor.
Sign it. You don't need to give it back to me. All right. Just fill it out. Court does call the case of the people versus Tabitha Cheney.
Actually, one of the people.
Should to tell your attorney to come on up.
Sorry about that, Your Honor.
What? What?
I'm sorry, Your Honor.
Did you see that? She's like,
Mini crisis. No. Assistant Public Defender Natalie Pay on behalf of Ms. Cheney, who stands to my right. Please state your name for the record, ma'am.
Tabitha Cheney.
Thank you, Your Honor. There was an offer made in this matter by the people late last night. We are respectfully requesting a very brief adjournment so I can have a fully informed discussion with my client about that offer.
October 17th, 2024, 9 a.m. Bond will continue.
Okay, thank you.
Thank you, Your Honor.
Court calls case people versus Jerry Jackson.
Judge, court shall fees for assistant
Jerry Jackson. Morning, Your Honor.
Thank you, Judge. Last time I spoke to Mr. Jackson, he was out of custody. There is a bond violation, and now he is in custody. So I guess I'm going to want to address bond at some point, Your Honor.
Today?
It's possible.
Okay.
But we were working towards a potential resolution on this matter and in negotiations. So I'm requesting a 2-week adjournment to conclude those discussions.
October 17th, 2024, 9 a.m. Esteban.
Thank you, Judge. My understanding is that Mr. Jackson, I reached out to Mr. Jackson last week when I received a letter from Community Corrections that he had tested positive for a few times for narcotics, Your Honor. That should be in your file, I assume. At which point I told him about the positive test, and I informed him that he had to get a handle on it and continue testing as ordered by the court. He then began going to NA and AA courses, began looking for a sponsor, and looking for a outpatient treatment program. I don't know if he was able to complete the outpatient treatment program.
I wasn't. I was arrested at Community Corrections the last Monday morning.
So he had at least what 5 days of NA and AA classes prior to testing at being arrested at Community Corrections this past Monday. He was on his way to try to get the outpatient rehabilitation set up, and he was taking the matter very seriously. He is hoping that the court might consider either today or at the next court date releasing him so that he can continue his NA programming, get into an outpatient programming, and maintain his employment. At this time,
on August 28th, he tested positive for cocaine and amphetamine.
Yes, Judge.
September 6th, positive for cocaine.
Yes, Judge.
September 12th, missed.
Yes, Judge.
September 16th, positive for cocaine.
Yes, Judge. He did all that, Judge. Not denying any of that. He did all that. Obviously, he.
I'm willing to do treatment, Your Honor.
Obviously, he had the problem, Your Honor. He's hoping to find a way where he can, at some point, get out to maintain his.
The problem is, I don't have a doubt that you're willing to do treatment. The problem is nothing is set up for him.
Correct.
And I can't trust him to be out on his own and do it because you messed that up.
Well, last time I spoke to him, he was out. Now that I know he's in, I'll get something set up by the next court date. If that's acceptable to Your Honor to consider at that point.
I will. All right. At this time, however, motion for bond reduction is denied. Bond will continue.
Thank you very much, Judge.
Thank you.
All right. Give me a call. Got a call. Thank you, Judge.
Thank you. That's called the case people versus Michael Chase.
That's
Good morning, Your Honor. Alexis Earp, student attorney on behalf of Mr. Michael Chase.
Go ahead.
So, as of this morning, Mr. Chase is currently incarcerated in the Sanilac County Jail. So we did not have a chance to meet with him. And when reaching out to that facility, they also indicated he's a federal detainee with the U.S. Marshals.
Ooh.
So we need some time to figure that out.
What happened there? The marshals got it.
How much time do you need to figure that out?
I would say 3 to 4 weeks. I will not be able to do the visit with him because I do not have a bar card, so somebody else in our office will have to do that. I will not be able to do the visit because I do not have a bar card, and that facility requires that for visits.
I think Bellinger's, he's not using his.
I'll do it.
No. All right.
I'm not using mine.
Just. Probable cause conference. Let's just go to October 31st. Sounds like you got quite a bit to figure out there in this.
Yeah.
2024, 9 a.m. bond continue.
Thank you, Your Honor.
Turn him over very easily.
Thank you.
Court calls case People versus Princeton Earl Jones.
Actually, wanted for the people. Ms. Plumine.
Thank you, Mr. Bellinger.
Who am I appearing with and on behalf of Mr. Jones? I believe my adjournment sheet is up there this time. I found out after I met with Mr. Jones.
Slow down.
Yeah.
Take a breath. Your name, sir?
Princeton Earl Conway Jones.
Thank you.
Your Honor, we are requesting an adjournment. I think just 1 week would be fine. I did find out after I met with Mr. Jones at the jail yesterday evening that he would not be a good candidate for drug treatment court. So I would just like an opportunity to talk to
with him about that.
Go over his options again.
Probable cause conference, October 10th, 2024, 9 a.m. bond continued.
Thank you, Your Honor.
All right, thank you, sir. Court calls case People versus Ratasha Cooper.
Actually, wanted for the people.
Public Defender Natalie Pate with and on behalf of Tasha Cooper, who is approaching. Please state your name for the record.
Tasha Cooper. All right, thank you.
Thank you, Your Honor. May counsel and I very briefly approach?
Sure.
Yes.
Thank you, Your Honor.
Went forth one today. Okay.
I'm reading.
You had 2 of them.
I'm reading right now the rules in Virginia with that. Is it Banfield case that's coming up? Holy cow, Virginia is a bear to get into. Pool eligibility and access. Oh my goodness. We might not be able to get in there. Holy cow, that's tight. By law, the Virginia Press Association is the governing body for still photographers. Only Virginia newspapers and news services are eligible for pool participation. In all cases, local photographers have priority over out-of-town media for pool access.
Yes, Your Honor. To receive some financial records from Ms. Cooper regarding possible financial or the restitution payments made in this case before the people are willing to extend an offer.
Got it. How much time?
I would ask for 2 to 3 weeks, Your Honor.
Cause conference, October 31st, 2024, 9 a.m. Bond. Thank you.
Thank you, Your Honor.
Oh. Now I remember. He comes back to find me to tell her something. Courthouse case, People versus George Lewis.
After one for the people.
The Water Assistant Public Defender.
Your name, sir? George Lewis. Thank you.
Judge, we have set the matter for preliminary examination.
Well, the Snowbirds complaint.
To my knowledge.
People would have their witnesses available the 15th. Preliminary examination in person, October 15th, 2024, 9 a.m. before Judge Barr. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Kevin Duke.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Duke. Would you approach him now? Mr. Duke, will you state your name for the record?
Kevin Duke.
Thank you. Your Honor, there has been a misdemeanor offer extended. However, we are waiting on some video discovery, so I would ask adjournment to review that.
Is the discovery on its way for you guys to review? Or?
Yes, Your Honor. It should be embedded to mediate.
Yes, correct.
Oh, okay.
It just wasn't discovered at the time that we sent over the original packet.
October 17th, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Joshua Quick.
And the Water Assistant Public Defender on behalf of Mr. Quick.
Joshua Ryan Quick.
Thank you. You're requesting an adjournment?
That's correct, Your Honor. We need the video of the forensic interview that it was turned over to us, but it included material that we were not supposed to have. So that was returned to the Michigan State Police Tuesday. I need the actual video, though, given to us correctly. So I would say 2 weeks would be sufficient. But
probable cause conference, October 17th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Christian Farley.
After Lonnie for the people.
Good morning, Your Honor. Alexis Earp, student attorney on behalf of Mr. Farley, who's present via Zoom.
Mr. Farley?
Yes, Your Honor.
State your name.
Christian Farley.
Thank you.
We would just be asking for a 2-week adjournment to have further plea negotiations.
Your Honor, there will not be a misdemeanor offer in this case.
Well, that kind of.
Whoa, shut it down.
You probably need a couple weeks to talk to your client still.
Probably, Your Honor. Yes, please.
October 17th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Not sure what he's charged
Your Honor.
with, but prosecutor says we are
Thank you.
not reducing these charges at all.
Court calls case People versus William Richardson.
Adam Mackey on behalf of Mr. Richardson. Please state your name for the record.
William Jesse Richardson.
Thank you.
Your Honor, today we're asking for a 4-week adjournment pending further investigation on this case.
4 weeks. Is this the only thing holding you, sir? Or?
Yes, sir.
Pardon?
Yes, sir.
Okay. Okay, I see. Probable cause conference will be adjourned to November 6th, 2024, 9 a.m. Or 7th, I'm sorry, November 7th. Thank you.
Thank you, Your Honor.
Bond continued. Court calls case People versus Autumn Bonte.
Assistant Public Defender appearing on behalf of, but not with, Miss Autumn Fonte.
Bench warrant.
Your Honor, my understanding is that my colleague asked you for an adjournment at the last PCC to have Ms. Fonte appear. Obviously, she struggles with some housing insecurity. My understanding there was a misdemeanor resolution proposed in this matter. My colleagues have had contact with her, but I was not myself personally.
Who are you throwing under the bus?
That would be me, Judge.
Okay, all right. Just checking. I just been. All right.
Stood up, so I had to Josh. Depends on what assistant public defender. I can report that Ms. Fonte did text me. She has a phone, but it doesn't have a cell plan, so she can communicate when she's connected to Wi-Fi. She did indicate that she had tested according to the court's order from the last day. I haven't received the results yet.
She tested when?
In the last week. I can see what exactly she told me.
The last report I have from October 1st, she had still missed all of her tests.
She reported to me via text message that she said she did test. She has another one for the court case. She said she tested in the last couple of days. She didn't specify what day it was.
I'm sure.
But she was able to test.
That was fine. The two of you did a wonderful job.
Did the best we could, Judge.
Yes. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you.
You're welcome. Court calls the case, People versus D'Angelo Simmons. Stop here. Oh, my recall.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Simmons. Mr. Simmons, state your name for the record.
D'Angelo Simmons.
All right, go ahead.
I believe that this is a competency review hearing, Your Honor. Is the court in receipt?
I have a September 23rd report finding him incompetent to stand trial and likely he's been opined incompetent to stand trial and likely to obtain competence.
Okay. That's the court. Well, we have no further evidence
regarding that. Any further evidence in people?
No, Your Honor. Thank you.
All right. Court would find the defendant is incompetent to stand trial, however, restorable with proper treatment. The public defender has presented an order. I will sign that order. Give me 90. We'll get something for it.
Thank you, Your Honor.
January 2nd.
I set a review hearing in this matter for January 2nd, 2025, 9 a.m.
Thank you very much, Your Honor.
Thank you. Court calls case People versus Daryl Johnson.
Ready again, Judge. And on behalf of and with Mr. Daryl Johnson. Mr. Johnson, please state your name for the record.
Daryl Johnson.
Thank you.
Thank you, Judge. I have had a chance to talk to my client and to the people on this matter. My understanding is that we are going to be requesting a brief adjournment so that we can do a little bit more investigation into this matter before trying to resolve it.
All right, how much time do you need?
Just a week or two, Judge.
Pardon?
Just a week or two, whatever's, of course, next date.
Probable cause conference, October 17th, 2024, 9 a.m. Bond will continue.
Thank you, Judge.
All right, thank you. Thank you. Anderson Keller. The court does call the case People versus Anderson Keller.
Ready, ma'am. Lauren Brown, Deputy Chief Defender, appearing on behalf of Mr. Keller. There is a date and time set for a competency review hearing. It is my understanding that Mr. Keller has declined the court's gracious invitation.
He has. He doesn't want to be seen today. That's
The record people don't have an updated report from the Center for Forensic Psychiatry.
it is a,
I was gonna ask for the adjournment anyway.
so we'll put it 30 days out at least, see if we can get a report November 6th or 7th. You know, you're correcting me, right? November 7th, 2024, 9 a.m. Trying to give me every other judge but the right one. All right, fine, we'll continue.
Thank you.
No. We're done. Court does call the case. What is this last one?
City of Wayne County, but they have not signed it.
You want me to call it now, or you want me just to hold it? Because they sometimes pop in. It is a private. Oh, okay. Court does call the case of People versus Carlos Harris.
Well, he's not enough to people.
No, it's Marcia. Go ahead.
Good morning. Marcia Crater on behalf of Mr. Harris. I would be requesting a 2-week adjournment in this matter, as I have been informed discovery is not complete.
All right, I'll grant it, but I would also note that the Wayne County Jail, which has the custody of this defendant, has not signed in.
Correct.
So what I'll do is I'll actually put it out 3 weeks, October 24th, 2024, 9 a.m.
Thank you, Your Honor. Appreciate you.
Thank you.
She interrupted
I
it.
got one. Recalls. Court recalls the case, People versus Jason Burkett.
Ready, Your Honor.
Absolutely, for the people.
Your Honor, I'm representing Mr. Jason Burkett, present. Right.
It's Matthew Burkett. Burkett.
Thank you, Judge. We're asking for a 2-week adjournment.
No objection. I do have to, he needs to be arraigned. This was amended. Counsel, have you received a copy of an amended?
No, I have not, Judge. No. They changed the case.
What was the?
Added a new charge.
Oh, yeah. Right, I got that, but you, we don't have another copy. Counsel, let me do this. Let me pass the matter briefly and we'll get you a copy of the amended complaint, because he needs to be arraigned on other charges. So I'll pass it till the next, I'll call him up first next month. Says warrants will be issued.
So that's our ways. I can't find the warrant.
Well, you don't have it.
Well, it's entered and I don't see that it was received.
Double check with them as to whether or not we have it. I'll call it. Court does call the case of the People's State of Michigan versus Maurice Todd Anthony.
Absolutely, for the people.
Warren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Anthony. Please state your name for the record.
Maurice Anthony. All right, so what are we doing?
I believe today the people have informed defense counsel yesterday evening that there would not be a misdemeanor offer in this case. Today during court, people became aware that the defendant does have an active felony warrant for his arrest that is pending within this county. I did inform defense counsel that you don't generally do that because this defense counsel in a very awkward position to not be able to tell their client or even tell their client that, but I believe they're going to be requesting a case and catch up.
Can you mute that? Mr. Brown?
Yes, Your Honor. We had planned to request an adjournment. On top of that, My client wishes to retain. He has had conversations with private counsel. So for
how much time did you need to do that, young man?
Well, we were fine with 3 weeks.
3 weeks would be fine. All right. Probable cause conference in this matter will adjourn to October 24th, 2024, 9 a.m. On this case, I will have his bond. Young man, what I'm going to do, and let me just, so that I can make it clear as to the other case, and I don't completely understand this. So we do not see the warrant when we run lean on him. I don't see the warrant. However, and it's a new case, which is a possession of cocaine case. While not seeing it, I have a JIS, a register of actions, that indicates on September 6th, the complaint was issued, a warrant was signed and issued before Magistrate Garwood. And that's the last entry that we have.
All right, I'm going to silence this for
typically
just
would
a minute.
mean that.
Hang on.
I don't know what that would mean, because typically what would happen is the warrant would then be entered.
So while they sort out this paperwork issue, I'm going to say we're about to do a poll. Because we're court hopping, I thought what better than to let you choose where we go. So here's what we're going to do. Let's see, super source, presets, one box, camera 2. Camera 1. There we go. Okay, so here we are in this court, and we're about to jump to one of the following. So let's zoom out and take a look here. I'm going to hit the poll here. Your options are top left, top right, bottom left, and bottom right. Just so you can look here. We have Cedric Simpson, where we're at right now, is top left. Top right is Judge Fleischer, who just barely stepped out on a break. Bottom left is Judge Stephanie Boyd in Maverick County, Texas. And I found a new one there in the bottom left. I don't know who that is, but it looks like they're in a break as well. We have one window open. It's not the judge. So we'll get to choose. We will go wherever the wheel points. It's like spin the bottle. It's like spin the bottle with court watching today. So I'm not going to vote. That way you guys can't complain about my choice. But whichever one we go to, it's, you got, I guess, starting top left to right. Top left, 1, 2, bottom left, 3, 4. So I'll give it just a minute to let you vote. Votes are coming in pretty quick. Let's see. It looks like we have a clear winner. We've got 53%. I'm going to end the poll. We've only had 155 votes. Well, let me give it a little second. Let me tell you, Judge Boyd is winning, hands down right now. Hands down. So if you think something other than Judge Boyd, now is the time to vote. We'll give you just a moment here. She's got nearly 50% of the vote. Okay, we're up to 200 votes. Still climbing. Judge is holding a lead, even gaining. She is at 50% now. Looks like we're going to make the switch here. 10 seconds. 5 seconds. We are ending the poll. Judge Boyd is the winner. She is on camera 7. We will turn on that audio and, let's go here. There she is. She's on camera 7. Where's our audio? She's muted the audio for this one. Let me double check, make sure I've got it right on my end. Nope, it's my problem. Fixed it.
Defense.
Charles Bunn for Mr. Trammell. Trammell, excuse me.
See, I was right. Are you Mr. Trammell?
Yes, ma'am.
All right, we're here. The defense has filed a motion to remove the GPS. State, is the court's understanding you're objecting to removal?
That's correct.
All right, and why is that?
Judge, I just became aware of that actually just right now. Okay. But we are opposed to considering the charges that presented in this case of terrorism threat and the safety of the community. I believe that GPS is appropriate in this case with the facts that are surrounding the case.
All right, defense?
For the purpose of the hearing, may I call my client?
Yes. If you can raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Marcus Trammell.
All right, defense.
And Mr. Trammell, how long have you had the monitor on?
Since after the Super Bowl.
Of this year, so
yes.
Basically February of
2024.
So that's
since the Super Bowl?
7 months.
Right? Since the Super Bowl?
And you had an attorney before I became your attorney, is that correct?
Yes, sir.
And then when I became your attorney, it was probably about 2.5 months ago. You still, at that point, even though your case was from January, you still had not been indicted. Is that correct?
Correct.
And then you were recently indicted August the 8th as a result of our filing a motion for an examining trial. Do you remember that?
Yes, sir.
Okay. Now, that you've heard the state say that their concern is for the safety of the community, et cetera. While you've been on the monitor, my review of your records are you've had no violations of the monitor. Am I correct in my review?
I believe so, sir.
Okay. And you understand that if the judge was to remove the monitor, one of the conditions she can set, of course, is you have no contact or you go nowhere within 1,000 feet of the employer that's charged you with this offense or that property. Is that you understand that?
Yes, sir.
You understand that if you were to be found to have violated that, she can revoke your bond and place you in custody until we have our trial.
Sir.
Are you still asking that the judge considers this motion?
Yes.
Can you describe briefly for the judge some of the hardships caused to you by the monitor?
I'm a disabled veteran, 20 years retired. I'm used to being able to have my freedom, be able to enjoy just getting out and about, dressing up. I do not feel like a human. I don't feel like I am being seen. I don't think I'm being heard. All I did was report ethical violations against me. I'm talking about the effect of the monitor. It has mentally destroyed me. I have given 20 years to this country.
Well, just 1 second. Here's my question. What type of GPS is he on?
I'm not aware, Judge. Sorry.
Is it full GPS?
I don't know. I've never been told what my restrictions were.
All right, so this is what the court needs to understand. Okay. And if somebody, I'm gonna have you guys step back.
Yes, sure.
If somebody can tell the court, is he on full GPS? Okay, so here's the thing, Mr. Trammell. Before I make rulings, I love having information. But I will tell you, if you are being upset, not letting your attorneys ask questions and interrupting, that's not a good look for what you're charged with. Okay?
Yes, ma'am.
So I need more information. I don't know if he's on full GPS, partial GPS. I don't know any of that. So if y'all will discover that and bring it back to me,
yes,
and then we will continue with the hearing.
Yes,
okay?
Yes, Judge.
All right, thank you.
Interesting. He wanted to get into his gripe session.
Raymond.
Yes, ma'am.
On Umberto Lira, what both of you in the state wrote down, what was the partial GPS on I'm sorry, you in the defense wrote down. I still think of you as being on the state. What was you guys wrote partial GPS to remain the same on weekends?
Well, technically he's not allowed to go anywhere on weekends because of the GPS, right? So imagine that would stay the same.
Okay. All right, because let me just tell you, if you do that, there's going to be a misunderstanding. Yes.
Okay. You can write over it that you like make changes, that's fine.
Okay.
As long as we're all understanding
all right.
what you're trying to do.
All right, thank you.
Right here.
Cookie, congratulations, 6 months. Looks awesome.
Yeah, CPS notified the document back on March. This is, yeah.
All right, thank you.
Fractured. That's no fun. I'm sorry. And then after causing you all that pain, they still charge
And
you.
I don't know, do y'all want to put the complainant's address in the motion?
So I was thinking about that, Judge, but I didn't want to disclose it also as public record. I mean, I can put it in there.
No, I mean, because then they won't know.
Okay.
Like pretrial services won't know.
Right. We can let it know.
Okay. Or either I can just put down residence and place of employment.
Okay.
And I'm assuming your client knows the residence and place of employment.
I don't know if he still does at this point in time, Judge.
Okay.
It's been a while.
I'm not sure what the charge was. He says it happened around the Super Bowl in February. He's on an ankle monitor. It was involving a company or a business location.
Counsel, yes.
Have they gone in, Judge?
No, they haven't.
Can I go outside the call?
Sure.
Thank you, Judge. I don't want to be outside when they walk in.
I don't know what that guy was charged with.
All right, so whenever you all are ready with Mr. Bunk's client, just let the court know. Okay. Domingo Rodriguez.
President, Your Honor. Rodriguez.
Okay. Oh, if he wants to come up now, I'll take this up and then we'll do that. All right, where are we on this case?
Yes, Your Honor. Having since just been indicted recently, it's the very first court setting where I've been able to confer with the state here in the courtroom. I looked over the discovery, Judge. It does seem light. There's 3 separate officers from Leon Valley Police Department, so I requested that the state look into that as well as a potential issue with the legality of the search, Judge.
All right, Ms. Ferguson, set this for discovery on November 4th. All right, is there anything else?
Nothing further, Your Honor.
Do you have any questions, sir?
No.
All right, we'll bring you back on November 4th.
Thank you, Your Honor.
Is it a possibility your client will be released from custody?
I don't believe so, Judge.
All right, Ms. Ferguson, if you could give him a reset just in case.
Yes, Your Honor. We'll execute.
Thank you. And counsel, on your client, your other client,
Yes, Judge.
the bondsman is getting off the bond.
Yes, Judge, became aware of that. I did file a motion for defendant's personal recognizance bond, the mental health bond. She does have issues, and she also does have an appointment with mental health courts next week on the 8th of October, Judge. And I have that referral here. I don't know if you wanted to take up the matter now or maybe a little bit later.
Just give me one moment because a judge is coming up to do a sentencing.
Yes, of course, Judge. I'll be around.
Thank you.
Yes.
We'll do no. Thank you.
Mr. Buck, you're back.
All right, just give us a moment because Judge Angelini is coming up very quickly to do a sentencing for a jury trial that he heard.
Okay.
It shouldn't be that long.
Okay.
Good news, I think, out for Virginia. Hoping, fingers crossed. I've got a form for access
Could I have
from
the
the
file
Virginia
on the case
Association
that Judge
of
Angelini is
Broadcasters.
hearing, please?
They are so strict in Virginia. You have to wear a dress shirt, tie, no tennis shoes, slacks.
Oh, so the interpreter is not here yet?
This is wild.
All right.
Women, business suit or appropriate pant outfit. Business dress suit or appropriate pant outfit. No hats. No
Charles,
hats.
I'll take your case. They're waiting for an interpreter.
Rob is in that area. Rob
All
knows
right,
the
Mr.
judge.
Trammell?
Rob likes the judge.
Sure. We're back on the record in 2024 CR 008165 State versus Marcus Trammell. All right, so the court has received a report that he is currently on tracking only, and that was modified to tracking only on March 18th, 2024.
That is correct.
All right, so what are the issues with tracking?
Well, the issue was he had made me aware of some physical issues, some medical issues, if you will, and that's what I'm
sorry, just one moment.
Of course.
Adam, we actually were looking at Judge Fleischer, who was, let's see, he's in box 2. He was right here. We were looking at Judge Fleischer just a minute ago.
Yes.
So he has voiced to me, he's had some medical issues that has caused him multiple times to have to switch it from one leg to another because and that's what I was trying to address with him, the troubles he's had with it. That's his biggest issue is his health. It's, without going into graphic health details in a public forum, he's had some medical issues related
so do you
to
have documentation of the medical issues?
Other than my client's statement, no, Judge.
All right. Has anything been given to the state? Are you aware of medical issues with regards to the GPS? All right. So, Mr. Trammell, I just deal in fact, right? So, if you have medical documentation about the GPS, present it to the court, and I will strongly consider removal of the GPS. But I need those documentations.
Yes, Judge. Okay.
So, and your attorney can bring you back on any date. If your attorney wants to come back on Monday, they can come back on Monday with the medical documentation. And I'll strongly consider removal of the GPS. All right. And then state at that
circle back to his setting before we're excused. Can we circle back to his setting? Okay.
Yes, we will.
Thank you.
So then in state, I don't know any facts of this case or what's being alleged. So that would help me with regards to whether or not removal is appropriate. Okay?
Yes, sir.
All right. So setting. When would you like this to come back for a hearing on the GPS matter?
Judge, I don't have an exact date. We'll have to see how quickly we can get the records. So.
All right. So this is what I'll do. I'll set you for a final discovery date in 30 days.
Yes, Judge.
And then if you have the records before then, you can always come back in. All right. So, Ms. Ferguson, if you'll put this for November 12th.
Judge, I come back on the 13th.
All right.
Can we just move it a couple of days after
Yes.
that?
Put it on November 14th. All right. Is there anything else?
Nothing else from the defense, Judge.
All right. Thank you.
Thank you, Judge.
Oh, thank you. You're excused. Thank you. And thank you for dressing appropriately for court. You always do, though. Morning.
She's here today. So.
Your right thumb in the blue light, press down on okay. Ready down.
Hey, come on up.
Sorry, Judge
Mr. Shell,
Boyd went on a break.
You were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand that this charge will go on your record. It will be there for the rest of your life. This also comes with an affirmative finding of family violence. What that means is that you can never own a gun or ammunition as a result of this plea bargain agreement as well. If you pick up a gun, you're in possession of a gun or any kind of ammunition, that in and of itself is a Class A misdemeanor and an arrestable offense. Do you understand?
Sorry, Your Honor.
You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. Is this what you want to do? How do you plead to the offense, or guilty or not guilty? I will find you guilty. I will send you to the agreement. It looks like you were also enhanced with your delivery of marijuana case out of the 177th out of 2004. Because of this agreement, now we will have to abandon the enhancement. You know, if you come to court, good things happen. We expect you to come to court, and when you don't, there are very serious consequences. You now will see. You now, all you're doing is racking up convictions on your record. All it's going to do is hurt you even more and more. Had you come to court, you probably would have gotten a great result. All you have to do is show up, and when you do that, good things happen. I hope that this is a lesson and that you learn.
If you come to court, good things happen.
When you pick up a case, just show up. Do you understand?
Sorry, yeah.
All right. Good luck.
Got off easy. Judge Fleischer has the ability to really dress you down.
Mr. Issue?
Verbally. And judge is looking for more Skittles. Checks the drawers, can't see any. Oh, there's some. He'll take those. He literally, he was grabbing his Skittles. I was joking, but he did. He does, his favorite candy is Skittles.
Okay, I'll text the coordinator.
Let's see, of all the other courts that let's see, we had Judge Simpson's on break. Judge Fleischer just left. Judge Boyd is still gone. The only one that's still working is right here. I don't even know what court this is. See if I can take a quick peek. Judge Cooney's personal
The
meeting.
complaint alleges that on or about August 28th, at a location in Traverse City and Grand Traverse County, actually the Grand Traverse County Jail, you were in possession of ketamine, a controlled substance. Is that true?
Yes, sir.
How did you know it was ketamine?
Because that's what I asked for when I bought it.
Yeah. Have you had experience with ketamine before?
Yes, sir.
So you know what it looks like and how it acts?
Yes, sir.
And was there a field test?
There was
Ms.
a
Roberts?
veterinary test.
And that showed positive for ketamine. Okay. What schedule is that?
I
Okay,
Schedule
and
4
you
drug.
knew what it was, and it was in your possession somewhere.
Yes, sir.
Okay.
Sorry, Judge, it's a Schedule 3.
Schedule 3? Okay. So I don't think it matters which schedule it is for this particular charge, but it is a controlled substance anyway. So are you satisfied there's a sufficient basis for the plea, Ms. Roberts?
Yes, Your Honor.
Do you agree, Mr. Fragel?
Yes, Your Honor.
Then to the charge of, in count 4, possession of analogs, a controlled substance. How do you put it? I'll accept your plea, find it's voluntary, accurate, and understanding. And the next thing that's going to happen is, are you going to take him over to the Department of Corrections right now? Okay, so they're going to prepare a report for the circuit judge so they can fashion an appropriate sentence. So please cooperate in that. They'll probably have you get a substance use assessment as well. Okay.
Simpson.
Let's see.
Overwater Assistant Public Defender on behalf of Mr. Brown, who should be appearing by Zoom.
Good morning, Assistant Attorney General Emmanuel Wutsa-Coker, on behalf of the people.
Mr. Brown, can you state your name for the record, please? Mr. Brown, I think you might be muted.
Lawrence Brown. Thank you.
I'll be asking to adjourn the probable cause conference. I have a social worker working on mitigation to send over to Mr. Wutsa-Coker.
All right. How much time do you need?
Just 2 weeks would be sufficient for me.
Without objection, probable cause conference will be adjourned to October 17th, 2024, 9 a.m. or as your invite indicates, bond continue.
Thank you, Your Honor.
Thank you. Hold on. Court calls the case People versus Jeffrey Pond.
Good morning, Assistant Attorney General Emmanuel Wutsa-Coker, on behalf of the people.
Assistant Public Defender Natalie Pate with on behalf of Mr. Pond, who is present via Zoom.
Mr. Pond?
Yes.
I need you to turn on the camera, please.
How do I do that? Oh, okay.
Put a thing that looks like a camera. It'll have a line through it.
Oh, there I go.
There it is.
Yeah, click on it and the line goes away and there you are. Your name?
My name is Jeffrey Pond.
All right. He's waiving preliminary examination.
That is correct, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Correct.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes.
People also waive the right?
Yes, Your Honor.
Preliminary examination having been waived, defendant's bound over to circuit court on the single charge.
We acknowledge receipt of the information. My client stands mute.
Defendant having waived former reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
November 13th at 1:30 before Judge Conlon.
November 13th, 2024, 1:30 before Judge Conlon.
Trying to keep us with active courts here.
No, it's just set a bond because you remember without bond. I believe last time it was 10,000, Judge.
All right, we're going to go on the record. Could everyone please whisper? Court is calling 2022 CR 4501, State of Texas versus Samantha Lee Lopez. Can I have parties announced for the record for the state? Defense?
Amir Memori, Your Honor.
And are you Samantha Lopez? Miss in Maverick County,
Yes,
are you
I am.
Samantha Lopez? All right, the defendant is appearing by Zoom. Any objections from the state?
It's a little
Any
delayed.
objections from the defense?
No, Your Honor.
Ah, she's frozen. Okay. All right. So we are here, counsel. You're requesting. Do you all have the phone? Thank you. Counsel, you're requesting a bond be set?
Yes, Your Honor.
All right. So why was she remanded without bond?
Judge, I believe I was retained on this case earlier this week. My understanding is she failed to appear for her prior hearings, Judge. I don't know if it was a trial setting or a sentencing, but she failed to appear.
All right. You want to call your client to find out why she wasn't present in court?
Sure, Judge.
All right, Ms. Lopez, can you raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
You can lower your hand, state your name for the record, please. Thank you.
Samantha Lee Lopez.
All right, defense.
Ms. Lopez, my name is Amir Memori. We haven't met, but I was retained by your family to represent you. We're here today to set bond because we managed that bond. You were set, Judge, when was she set here last time?
June 6th.
June 6th of 2024. Can you tell the court why you failed to appear, ma'am?
Oh, I'm sorry. Let me correct that. It was June 6, 2022.
2022, yes.
Yes.
Can you tell the court why you failed to appear on that date, ma'am?
I was not aware that I had a court date because I was not following along with anything that I needed to take care of.
Okay, I don't understand that last statement. You said because you were not following through with what?
With any of the things that I was supposed to. I wasn't talking with my lawyer. I wasn't checking in with the courtroom. I wasn't doing any of that.
I think, Judge, she takes responsibility for that. So I think
Yes.
last time the bond was set at 10,000.
Oh, just 1 second.
Sure.
State, do you have any questions?
Yeah, so why are you at the Maverick County Jail?
Why are you at Maverick County Jail?
I went into Mexico for a dentist appointment, and when I was crossing the border back, they ran my name at the border, and I came up with 2 warrants.
What are the warrants for?
One is for DWI and one is for assault.
If I may, Judge, County Court 6 has set her bond at $5,000. That's a DWI case.
All right. Any other questions?
No questions.
All right. All right. Do you have a place to stay? If you're released, do you have a place that you can live?
What was that?
When you,
Oh, yes, ma'am. I have my own home.
All right. You have your own home?
Yes, ma'am.
Who is in the home with you? Any minors?
No, ma'am. It's just me.
All right. Do you have any children?
No, ma'am.
Any drug or prior drug use?
No, ma'am.
Any prior mental health issues? Any prior mental health issues?
I have when I was younger, ma'am, but not recently, not in a lot of years.
All right. And what was your prior mental health issue?
I was suicidal and I had anger issues.
All right. Are you currently under any type of a doctor's care for mental health issues?
No.
Since you've been in custody in Maverick County, have you experienced any mental health issues or have you been given any type of mental health medications?
No, ma'am, I have not had any issues.
All right. Anything else from either side?
We had a hearing yesterday, Diane, where she testified. You'll want to watch that.
Absolutely, Judge. On the 10,000, I'm not sure. I think that was what the amount is, but I'll leave that to the court's discretion to confirm that, please. I want to make sure that that was my understanding, but I may be wrong.
All right, Ms. Lopez, are you able to afford a $10,000 bond?
Yes, ma'am.
All right. The previous bond was actually $20,000.
$20,000. Okay, Judge. I'm sorry.
All right. That's fine. I mean, both parties have agreed to $10,000. So the court will set your bond at $10,000. There's be no contact with the complainant or the complainant's residence or place of employment.
Okay, yes, ma'am, that's fine with me. I haven't spoken to her in a few months.
All right, and then this is going to be set for hearing in this court. Defense, have you received all of the discovery?
Judge, I have, yes.
State, were you able to tender an offer or no? All right, so this is going to be set for October 28th. Is that a good date for you?
Yes, Your Honor.
All right, it's going to be set for October 28th for a plea deadline date. Of course, if your client is still in custody, the court will reconsider.
Thank you.
All right,
Amanda,
is there anything else?
When we go to lunch,
Judge,
remind
we
me.
greatly appreciate the
Let's
court's
end
time
by singing
and,
happy birthday to Amanda.
In Maverick County.
Yes, and getting this together in Maverick County also, Judge.
All right, thank you. So your next court date is October 28th. You need to make sure that you're here in court. It's at 9 a.m. You understand?
Yes, ma'am, I will be there.
All right, thank you. Have a good day.
Thank you.
All right, thank you, Maverick County.
Thank you, ma'am.
Thank you.
All right, you're excused.
Thank you, Judge.
You're welcome.
Oh, do you want to take that to the back or the clerk?
Oh, I'm going to hand it to them.
Okay.
And if you want a copy of it, just remain and they'll give you a copy.
I would, Judge, please.
Sure. There you are.
New arrivals coming in.
Mayor, do you just want to take a photo of this? You're short-handed right now.
Can I make a copy in the back?
Somebody in the back.
Okay, let me go to another court. I'll be back. Make a real quick copy. I'll be back.
My girl Angie, happy belated birthday to you. Almost a week ago, or half a week ago. It is a court holiday, I believe, in Florida. Okay, judge is awfully quiet. She still sits there for too long. We're going to jump up to Cedric Simpson. Fleischer's still on break, eating his Skittles. Credence and Mikey. Oh my goodness. You guys, if you don't follow Credence and Mikey for police chases, they're on it like Blue Bonnet. I know that's an old reference, but I'm an old guy. They are a lot of fun for police chases. That I don't know how you go live so fast. I think Credence and Mikey, they both sit there at their computers just waiting for the notification as soon as it comes in, and they're like, go live. Anyway, yes, followed you guys for a lot of years.
All right, one Uribe.
Love it. Is that one guy going to prom?
Hello.
The guy that's all dressed up.
Mr.
He was
Uribe.
best dressed in court.
Hello. All right, so today is plea deadline date.
Yes, ma'am, and we will be turning in our pretrial diversion application this morning.
Okay.
We occasionally follow a couple police chases.
All right, so you're going to be
thing,
reset
once in a while we'll follow them.
for November 4th. Is there anything else?
No, Judge.
All right, thank you for dressing appropriately for court. Just remain in the courtroom, and the coordinator will give you a reset date for November 4th.
Thanks, Judge.
This is your plea debt. I
wasn't
PTD.
expecting that voice.
You're welcome.
The voice surprised me. I thought it was somebody else. Our favorite on the channel, our favorite police chase was the bus, the off-road bus, school bus. Oh my goodness, that was crazy. That was wild. We have something. The music we used when we followed that is a little one of our favorites on the channel. We call it this one. This is the music we had on that bus chase, and it was wild. I narrated it as best I could to describe what was happening. But
Joseph Jefferson Smith. Hello. Morning. How's it going?
It's going good.
Because I'm the attorney. I'm
All
the one
right.
facing jail time.
So let me just put him in the system.
I think this guy can bench like double my body weight. And that's saying something. The guy is ripped. He's built.
All right. So on this case, where are we on discovery?
I just did the discovery acknowledgement this morning. We have everything.
State, were you able to tender an offer?
Not at this point. We haven't got anything.
All right. Do you have an offer to tender today?
I see some similarities.
All right. When will you be prepared
With
to
Sheriff
tender an offer?
Steins.
And tender an offer today. That's what they're trying to do.
I didn't approach him on an offer, so.
Okay. So I'm going to have you all get an offer before you leave the courtroom. And this is going to be set for, how old are you, sir?
43.
All right. So this is going to be set for a plea deadline date. Norma, put this on November 7th for a plea deadline date. All right. Your plea deadline date is going to be November 7th. All right. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
All right. Thank you.
Thank you.
You can go back to the weight room and continue lifting. That guy's his upper body is huge. Okay, I'm jealous a little bit. I got like a tiny bit of jealousy, but I have not been putting in the work that he has.
Thank you.
Oh, okay.
I can have your defendant's email
Got it.
address.
Got it.
James Austin.
If I can indulge myself, if that's even a term, let me mute the judge just for a second here. This is my favorite sound effect ever, as far as announcing, like news announcers from a helicopter for a police chase. This was my all-time favorite.
This police unit is trying to box him in, but instead he just crashes into the tree, and away he goes. But let me widen out. I don't know how far this will take him. Yeah, he's basically cornered. Wow, look at this. Off the road and onto the freeway. Oh my gosh. So he is on the freeway.
I think that's the one that ended in Denny's. The guy ran into the Denny's or something.
All right, State, have you seen the motion?
But he's aware of what it, he knows what it says.
Okay.
Well, this guy's huge. Like he's a giant of a man.
All right, court is calling NIMAC number 758035, State of Texas versus James Austin. Can I have parties announced for the record for the state?
Daniel Rosengard for the state.
For the
Charles
defense?
Bunch for Mr. Austin.
Right, and are you Mr. Austin?
I'm James Austin.
Just a moment.
Who's talking in the background?
All right, let's go off the record for a moment.
Uh-oh.
So this case is an injury to a child, correct?
Correct.
All right, and the children that he wishes to see are one of the children the alleged complainant?
Yes. And they're all present, and the state's had an opportunity to talk to them today.
All right, and is CPS involved or no?
No, Judge.
State, are you aware of CPS is involved?
I do not have any knowledge of CPS involvement at this time.
Did anyone check? Is there some documentation that CPS ever go out to the location? The reason why I'm asking these questions, because if CPS is involved, they will have certain conditions.
He's holding his hat in his hand, literally.
Yes, there is a CPS case, and the case I
All right, so here's the thing, Mr. Austin, before you speak, because there's information that I need. I know you're saying that the CPS case, maybe it's closed or maybe there are no conditions that have been set. But what I've discovered in my previous lifetime working CPS cases, sometimes the clients think something has happened and it hasn't happened. So here's the problem with me entering any orders. And I'm not saying I'm going to grant your attorney's motion or not, but I need to know if there are CPS orders and what those conditions are. Yes.
Yes, ma'am, with all due respect.
Okay, don't ever do with all due respect, because then what follows, people
I wasn't aware of that.
Yeah, that's what
hard,
people always say.
Trying to be nice about it.
No, I appreciate it.
Appreciate that.
Yeah.
Well, I spoke with the CPS lady, and my wife has suffered with mental health throughout the years. I believe in the sanctity of marriage, so I didn't divorce her. The children were released to my custody. She left the children for over 30 days.
Okay, so wait a minute. Let me wait. Let me stop you right there. All right. So I want everybody to be in a place of kindness, right? And to be in a place of kindness, you don't say you're only staying with somebody because you believe in the sanctity of marriage. And you don't put, for lack of better terms, their issues publicly before the court when it's not needed. This is what I need. What I need is somebody, if you know the caseworker's number or something that's going on, pick up the phone, call the caseworker, and guess what? The state and the defense can talk to the caseworker. They're going to ask for the name of the oldest child, and they will go in their system and they're going to look it up and they're going to see what the status of the case is. Okay. Either they're going to tell me, yes, we've closed the case and the children are supposed to be with you, or either they're going to say, you're not supposed to have contact.
That's all I was just trying. That's all. I never get into that.
So let's land the plane by having somebody call the CPS worker, and then I'll take up this matter.
All right, thank you. Okay.
Okay.
Will they let me know, the CPS people, if it's okay?
Sir,
your attorney and the state are going to call the caseworker.
Yes.
Okay. All right.
Land
Lindsay Hernandez.
Present.
Yeah, the judge shut that down real quick. They've gone off. Let's see who we have again. Let's jump back to.
That they know how to get in touch with you. All right.
Well, it's
going to be spotty here and there because with my job, like I said, when I'm out at the farm, out in Plymouth, I have no signal.
I heard that.
And so the number he texted.
If we leave you a voicemail, sir, just return our voicemails, okay? When you have an opportunity.
Yes, sir.
Okay, thank you.
Real good. October 24th.
Thanks, Judge.
2024, 9 a.m. Bond will continue. Thank you, sir.
Oh, and Judge Simpson, I want to let you know, I have housing and a job now.
You have what?
I have housing and a job now. We're no longer homeless.
That's fantastic. When did that happen? You got that taken care of?
Less than 24 hours after my fiance bonded me out, I called a farm, Donahue Farms, and got a resident farm hand job.
Fantastic.
Job came. I wanted to make sure the courts knew that.
All right. Very good. Okay. We'll see you in a few weeks then, Mr. Redland.
All right. Thank you, Your Honor.
Thank you, Your Honor.
Yes, we all did.
Oh, he got a job that includes housing.
Okay. Can you bring what's his name? What's wrong?
We cannot tell you.
We cannot all go.
You never want to know. You never want to know.
Okay, listen. You do understand you're in my court. So what are you not telling?
Really want to know.
You really want to know. You nominate Mr. Overwater to approach and tell him.
Volunteer tribute. Oh, yeah, I could approach it.
Yeah.
You really want to know.
You can actually the word farmhand differently.
And there was a space between. He got a job.
As a farmhand.
But somehow they lost the farm. They lost the farm.
You know what? You're right. I didn't want to know.
We tried.
I know.
And that happened.
Did we adjourn this other one? What day?
Somebody had a dirty mind and heard something inappropriate. I wonder why the girl there in the white and black checkered shirt, what she's there for. There she is, in back. She's not nearly as interested or as bored as the girl behind her, but...
Well, while we're waiting on
there.
this,
yes.
Do we have an interpreter?
We do. Would you like me to?
Yes, let's get her sworn in.
Good morning, Madam Interpreter, you're in front of the Honorable J. Cedric Simpson out of the 14A District Court, Washington County, State of Michigan. With one matter this morning. Can you please raise your right hand? Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish to English, the manner now before the court, so help you God?
Yes, I do.
Her shirt says
Good
languages.com
morning,
or
Ayden.
something.
Good
Good
morning,
seeing
Your
you.
Honor. Likewise.
Court does call the case of the people of the state of Michigan versus Giselle Hernandez Zaldivar? Hold it. Go ahead, Madam Interpreter.
El estado de Michigan está llamando a Giselle Hernández Sandoval. Suena.
Jessica Blanchard here on behalf of the people.
Y aquí estoy representando a la fiscalía.
Brian Bowling on behalf of the defendant.
Brian Bowen de parte de la defendida.
Can you state your name, please?
¿Puede decir su nombre, por favor?
Cel Nicole Hernández Saldivar.
Your Honor, we're asking for an adjournment to allow my client to consult with an immigration lawyer regarding these charges.
Su señoría, voy a pedir que hacer una pausa a la sesión o suspender la sesión para que mi defendida pueda hablar con un abogado de inmigración sobre su asunto acá en la corte.
There has been a referral made internally through our office, but that attorney has not reached out to my client yet.
Ha habido un referido interno en mi oficina para este tipo de abogado, sin embargo, este abogado no se ha comunicado con ella todavía.
I would request 28 days.
Yo quisiera pedir 28 días.
I will adjourn this matter to November 7th, 2024, 9 a.m. Bond continued.
Y la fianza continúa, vamos a retomarlo entonces para noviembre 7 a las 9 de la mañana.
Thank you.
Thank you, Your Honor.
Thank you.
All right.
AZDCS,
Thank
I
you,
really
Madam
love these
Interpreter.
Rode
Always a
wireless
pleasure.
mics.
That's
DJI
it
makes
to
another
me.
one.
Have
That's
a
really
nice
good.
day. Bye-bye.
You too. Bye-bye.
They're absolutely phenomenal.
Court does call the case of the people of the state of Michigan versus Maurice Todd Anthony. This is on case 24 F55655.
Thank you, Your Honor. To allow you to the people.
Honor, Lauren Brown, Deputy Chief Public Defender. Has our office been appointed in this matter?
You have not. Mr. Anthony, you are before the court on a felony. That complaint alleges
Yes, I'll send you a
that
link.
on or about May 10th, 2024, at the location of Liberty Street near Maynard in the city of Ann Arbor, Washington County, state of Michigan, that you did knowingly possess less than 25 grams of a mixture containing the controlled substance of cocaine. You understand the nature of that charge, sir? Yes, sir. All right. That is a felony punishable by up to 4 years incarceration and or a $25,000 fine plus court cost. Do you understand that? Yes, sir. All right. Now, first question I have for you, sir, is do you want to be represented by an attorney? Yes. Public defender, please.
Thank you, Your Honor. At this time, we are respectfully requesting that my client be allowed to enter a plea of not guilty and that a probable cause conference date.
All right. Waive the timelines on this so I can set it for the same one.
Yes, please.
All right. Defendant having pled not guilty, demanding a preliminary examination. I will set a probable cause for October 24, 2024 at 9 a.m.
May we address the issue of violence?
You may.
Your Honor, my client has appeared, certainly court dates, which were set, I believe, that it's a danger to flee. we will again continue to turn to all future court dates. We're asking that the court set either a PR bond or a bond of 5,000, 10% allowed.
Any response to bond from the people?
Your Honor, does the court still have the companion file that was up earlier today, 24F20?
I do.
Thank you. Your Honor, in that file, the defendant had not been testing. It appears that the last court date on September 12th, that's not addressed, and we had adjourned again to hire an attorney. But the community corrections report that people have that I'm reviewing, in that case, seems to indicate that he submitted tests on September 4th, August 30th, August 22nd, August 12th, August 9th. The body of the report states well that the defendant was hoping to
substance abuse
test at on-site, and the results were to be forwarded, but community corrections hadn't received any results. So I originally asked the question, body which does seem to make sense for a possession case in a lot of ways. The concern of the people is just that the defendant doesn't make him compliant with his bond conditions in all of his pending cases and does test.
In response, Your Honor, my client indicates that he is testing. He's testing Ypsilanti. That the emails to verify his testing have been sent to the wrong court. Can you?
They were sending it to the court instead of the community corrections, which they were, and I told them to, you guys gotta get it sent to the community corrections instead of the court, and he fixed it, and I'm all caught up on all my testing because I've been testing every week, once a week.
Because you're on weekly testing?
Yeah.
Standard supervision. I'll need an order for this file. All right, what I will do in that instance, I'll set the defendant's bond at 10,000 personal recognizance bond, all other standard conditions, including no assault behavior or possession of weapons. You understand that, young man?
Yes. Yes. Yes.
No possession or use of any alcohol, recreational marijuana, or any illegal drug. I'll order testing, which is consistent with the other thing of standard supervision, and I'll signing that order right now. All right, so I've signed that. Double check before you will release you. Before you leave this campus, go over and check with community corrections because you're under a new order, just to make sure they've got it. Okay?
I will.
All right. Thank you.
Thank you.
Is that it till when? Wow, I get lunch.
Hey.
Wow.
If we have got a break, we get to sing to Amanda H.
That's when you eat, right? Okay.
Lunch is when you eat.
All right. I'll give it a shot.
I'd like to say that I have a hard job to do, but I don't want anybody to misunderstand that.
You just gonna leave?
I said no.
No.
Yeah.
We decided to mess with Mr. Allen, make a joke, Mr. Allen did not find that funny.
Okay. All right, I'm out. Well, court stands in recess, I guess, when again.
All right, so he bails on us. Where does that leave us with? Who's left?
With the GPS.
Bench court was issued when he failed to appear for a pretrial conference.
So we've got Fleischer's still. I think Fleischer's gone. I think he's actually on break. I don't think that's real. Well, no, he's gone. We've got that Chisholm down here at 8. Let's see what this one is.
So I'll renew that.
Boring.
Also,
let's go to Boyd.
State Board of Dental Assistant, since it's on the record, I can't renew my license for that.
Since what is on your record? Is it
it's this case, it's like showing pending, I guess. So with this being on there in the house arrest, I'm not able to work anywhere because of that.
Well, no. I'm sorry to keep up interrupting you, but are you not allowed to work in your chosen profession because of the charge or because of the GPS?
Oh, because they let me go because of my ankle monitor. But if I wanted to renew my license with any other dental offices, because I have tried to get another job with the dental, but because of the pending, it won't allow. But my current, well, Recess Dental, which is where I was working at, they let me go because of the ankle monitor. They said I can go back if it was removed. So I haven't really been able to find any work. Bond is paid. I was getting like little jobs, but I was working at a daiquiri place and then the company just like sold out, or they just went out of business. So it's been hard since then. Dental office did say I can go back if the ankle monitor is removed, and I can finish with my position there as a dental assistant.
Okay. All right, so here's my next question. Is there any letter or anything from that facility that's saying that they will allow her to work there if she doesn't have the ankle monitor?
I can get that for you if you need. But it was my doctor that told me that. My doctor, both doctors that I worked with, they did state that to me, and the manager.
Okay. Any other questions?
Nothing else, Judge.
Any questions?
That's interesting because that's
All right,
purely
so
optics.
I want to see that documentation that they're saying that they would allow her to work there if she didn't have the ankle monitor on, because this seems to be the crux of the situation before the court. Is she wants to work there. They're not allowing her to work because she has an ankle monitor. And then state, if the court were to grant this when we come back, I would want the complainant to be informed if the court were to remove the ELM.
I believe there's no contact with the complainant already, and there hadn't been any problems.
Okay.
No violations on ELM.
Okay.
There's really nothing else in her background that would suggest she needs this.
So as soon as I receive that documentation, or if they want to zoom in, they can zoom in today. But as soon as I receive that documentation, we can put this back on the docket for hearing at any time you have that, counsel. Anytime except for Friday, because Friday is drug court graduation, and that's where I'll be.
Yay.
Okay.
That's awesome.
Sure.
So it's also been a problem for any other jobs that I've tried to apply at. They see the monitor and they don't want to hire me.
Okay.
So it's not just the dental office, but it's other employments that I've tried, and I have proof of like Indeed and stuff, that they see my ankle monitor and they see.
All right. So again, with other employers seeing your ankle monitor pants, right now, what you've informed me of is that you have a job as a dental assistant, and that employer is saying they won't let you work with an ankle monitor. So I want that information.
So I'm not currently employed with the dental office. It's been a year. They let me go a year ago.
All right. So
But
no.
to go back.
Yeah. So I need that documentation. So does everyone understand what the court is asking for?
Yes, sir.
Okay. All right. So we'll come back on November 7th for discovery, but counsel, you can set the other matter anytime before then.
Yes.
All right. Thank you.
So pants are the secret. She has pants on.
Virginia Bella Torres.
Yeah, I feel there might be some untruthfulness in
And
there
is there an
somewhere.
application in this case?
There is not, Your Honor.
Okay, we're gonna do this. It's noon. It's time for lunch. Holy cow! Just saw this guy.
Yeah.
Oh, not him. The other dude. It was a nostril cam, but it just surprised me. Hang on.
Green Lake. Do you know the zip code there?
I'm not sure offhand.
Do you know where Green Lake, Michigan is located near?
It's near Union Lake, Michigan.
Lots of lakes in Michigan.
It's near Union Lake, Michigan.
All right. Anyway, we'll leave them be. We're gonna go to we're gonna go to lunch, which means before we leave, we have to sing happy birthday to Amanda H, who slept in, which is her right to do on her birthday. But we're going to sing happy birthday to Amanda H. She's been a longtime supporter of the channel, as you can see by the orange courthouse next to her name. So warm up with me one more time, if you will. La 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 la. Excellent. Amanda, we're going to sing just one verse just for you, then we'll cut it short. That's all you get when you're late. I apologize. Here we go, everyone. Dancers, one more time. Happy birthday to you. Happy birthday to you. Happy birthday, dear Amanda H. Happy birthday to you. Amanda, all the good wishes that we wish to others who had their birthday today, who were on time, we extend to you as well. The only thing I can say is you might be too late for your pre-pancakes at Denny's or IHOP or Village Inn or Waffle House or any of the other places, Amanda. But have a happy birthday. You realize there are a million places you could be in, a million people you could be with, but you've chosen to be here with us. Hopefully your day is absolutely wonderful, even if it was just a little bit late this morning, which I will point out one more time, not my fault. Amanda says, thank you, Ari. Best way to spend my birthday. We're going to be back to spend the rest of Amanda's birthday with you after lunch. We're going to take a brief break. Just know we are court hopping as we prepare for Sarah Boone to start next week. It starts with jury selection. I've got some calls to make. We're still working with the court, trying to get everything lined up properly because they're almost as bad as Virginia to work with. Let's see, what county is that case in Virginia? Fairfax County, Diane. It's Fairfax County. I've got my forms lined up. I have to get with the Virginia Association of Broadcasters and file some court paperwork and things like that. It's gonna be fun. Weatherwatch says, "Is that my wife?" Similar name. All right. That being said, we're going to get ready, go to lunch right now. Everyone have a brief break. When we come back, we'll see if we can find maybe, I don't know, let's look at court. There's things happening around about. Let's see, that one's not maybe Judge Fleischer will come back. We might get some time with him. Ooh, there's a parole hearing in Louisiana. Check that out. Okay, so it looks like this.
All the appropriate places.
That's what I'm watching. I'll be watching this during lunch from all different sides. When some action happens or something interesting happens, we're going to be back with it. But first, we're going to get some food and then be ready for the afternoon. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe until we go live again after lunch. Give me about 45 minutes-ish, maybe 1 o'clock. Does that work? 51 minutes. I think I've got a text from my roofer who's going to come repair my roof from after the storm. That's good news. I'm going to go check the basement to make sure the sump pump's still working so it's not flooding from the bottom. I can handle one or the other, but not both at the same time. So we'll do that, and then we'll be back after lunch. Thank you all. Have yourselves a wonderful afternoon. We'll see you in a little bit. Bye-bye.
I don't think that's him, Mark. I don't think that's him.
Scratch all that. Oh, that was terrible. I apologize.